Chair will call the July 16, 2019 special city council meeting to order. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Clerk, could you please call the roll?
Alderman Redpath. Here. Alderwoman Simpson.
Here.
Alderwoman Turner.
Here.
Alderman Fulgenzi.
Here.
Alderman Proctor. Here. Alderwoman DeCenso.
Present.
Alderman McMiniman.
Here.
Alderwoman Connolly.
Present.
Alderman Donlin.
Here.
Alderman Hanauer.
Here.
Mayor Langfelder.
Here.
Mr. Mayor, quorum is present.
Thank you. Before we get started with the special hearing with regards to Ward 2 election, just a point of interest, I think I could speak for the City Council and probably the citizens of Springfield that everybody has actually a lot of concern with the direction we go. I mean, this is a big moment in time. As elected officials, we all know the importance of a vote. Hopefully residents realize that with what's happened and what's transpired. And it's really frustrating because coming from Alderwoman Simpson or Sean Gregory, we both have friends on both sides with regards to that. But most importantly, it's all the passion and work you put into it. Nobody wants to be in this position, and we want to make sure that we make a just and sound decision based on the facts. And I know it can be an emotional aspect, a lot of passion, and that's good for a community as long as we make sure that we do it civilly and move forward in a positive manner, regardless of the outcome. And that's, what I'd like to, express to everybody, because I think all of us are frustrated with how it turned out. You wish it was a slam dunk, but regardless, we need to move forward as a community, as one community, especially for the benefit of Ward 2, because Ward 2, quite honestly, came from the voting rights lawsuit, and that's what transformed into this form of government. So that's what we're representing everybody, but most importantly, the residents of Ward 2, and how we best can move forward together and make sure based on the facts and how we do that. So we appreciate everybody's participation with regards to this. As far as the hearing of this matter, state how I perceive the rules, but I'm sure Corporation Counsel will correct me or clarify it. Former Judge Mielik, he's the hearing officer that we asked to participate, take a look at the findings or the contestations with regards to the particular ballots. He'll give his findings, and then each side will present their case. And then after that, the council will ask questions with regards to from there. So anything I need to add, Corporation Counsel, or anything you'd like to add to that?
Just very briefly. The City Council in this context sets in really a quasi-judicial role, basically making a determination of an election contest in the under both the Illinois Constitution, the consent decree. The City Council is the final judge of the manner of elections relating to members of the City Council. And the parties, I would just want to make a note, have worked, I think, very well together. There's been, through this entire process, a series of agreed orders on how we would proceed. Tonight is the same, in the same manner. In its quasi-judicial role, the council will hear first from the recount hearing officer, who will take up to 15 minutes basically to go through the report and recommendations. Next, it will hear from the petitioner, which is next in order, as we would as if we were in court. Petitioner will have 15 minutes basically to make a response to the hearing officer's recommendations. Questions may be asked of the petitioner's counsel. Then next will be the respondent for 15 minutes with the same proviso. Then questions may be asked at the conclusion of their comments, and both of those are directed towards basically comments regarding the hearing officer's recommendation. Then the final item will be the recount hearing officer will basically have the opportunity for a reply, meaning be able to answer any questions that might occur in relation to any comments or questions that are raised by petitioner or respondent. So thereafter, Once that's concluded, then the council will deliberate. It is not, one of the questions I was asked, is it executive session? No, it is in public session. And the council will then deliberate, have the opportunity to discuss among themselves whatever the issues might be. Then at that point, it would be inappropriate to, if the council is satisfied, to make a motion regarding the hearing officer's recommendation to adopt it or to adopt it in part and modify it in part or whatever the decision is. Now, because of the nature of this process, this is not a council meeting where the public is involved in it. This is a quasi-judicial activity where the council is acting as a kind of a final fact finder or judge in relation to what the parties have presented. And again, I would just emphasize the parties have worked very well together. There's been an agreed process that has now brought us to this point. So the first order would be to call upon the recount hearing officer.
Point of order, Mr. Mayor.
Alderman McMiniman.
City Corporation Council, last meeting last week, you advised us that the parties, if they disagree with the results of the City Council decision, could take the case into circuit court. Does that remain your opinion?
There is a process called an action for what's called quo warranto. It's a common law action that is designed to allow the opportunity to challenge the decision of a legislative body. Typically, legislative bodies' decisions are not normally subject to challenge. There may be other mechanisms, however, that would remain to be seen on whether or not either party would determine they would like to attempt to take further action to review the City Council's final decision.
So the reason for asking that question is the following. If the council would anticipate or would potentially anticipate litigation following the City Council's decision, may the City Council go into executive session to assess the hazards of litigation?
I believe that in relation to the contest itself, I believe that that should be in public session. If a suit or action is taken, then it would be appropriate to discuss that in executive session.
So in the past, in anticipation of litigation, we go into executive session. But are you saying that in this case, we could not go into executive session in anticipation of litigation?
Well, I don't think perhaps after a decision is made. In other words, if the concern is some action is taken by the council in public session that could lead to litigation, then we can certainly discuss that. But what I'm wanting to make clear is that the deliberation of this matter should be in public, not in executive session. The substance, I'm referring to, the substance of this matter should be in public session.
Well, yes. We all agree that we should go into public session, but as we do for ordinances that are not yet voted upon, we will at times go into executive session to discuss the hazards of litigation and the merits of litigation before the council votes on the ordinance. So are you saying this is different than that?
I would advise the council to conduct its deliberation of the substance of the matter in public. The assessment of any potential risk relating to action that the council taken can be discussed in executive session. I do not believe the deliberation of this matter should be in executive session or any aspect of it.
Thank you.
So the first item on the agenda is the recount hearing officer will present a report and a recommendation of his findings.
Elected officials. That's what you are. You, more than anyone else in our community, understand what that means. You ran for election. You are sitting at those chairs because you won those elections. You went out in your wards. You asked for votes. You asked for people to vote. You asked for people to vote for you. We complain a lot about people that don't vote. that we have low turnout. And now here we are tonight deciding whether we should count some of those votes. It's not an easy thing to do. And you more than others know that. And you know that we have rules and procedures for these elections. And the reason we do this, especially, is to prevent fraud, to make sure that the results of these elections are protected. As is stated, how it's going to proceed as I go forward, then the attorneys will answer your questions. They have filed 4 briefs apiece, many exhibits, which I've gone through. They're well acquainted with the law and the facts in this matter and are very able and have done a wonderful job on both sides of the issues on these questions, and I believe they can answer any of your questions better than I can. And I can guarantee you that when they agree with my recommendations, they will tell you that I am brilliant. And when they disagree with my recommendations, they will say I'm an idiot, but in the nicest possible way. So let's get to my recommendation. We start out with, they stipulated that, and for the purpose of argument, I'm just going to refer to Simpson and Gregory. I'm not trying to be impolite in any way, just it's easier to do. They stipulated that Simpson had 464 votes and that Gregory had 460. I'm going to talk about the initials of the election judges and affidavits at the end. First, I want to address 5 other issues, which I think I can go through rather quickly. Number 1 was the ballot with regard to different ink for Gregory. I resolved in my mind that that should be counted, that it was not in any way trying to distinguish that ballot in any way, and the ballot should be counted for Mr. Gregory. Second was a ballot that was damaged for Mr. Gregory, and it was recreated at county clerk, and I believe it was done properly. A word or two could have been put on there differently, but all in all, I thought it was done correctly and should be counted. Then we have the overvote with regard to Simpson and Mr. Schaefer. Both of them, they filled out the ovals. However, with regard to the Schaefer vote, there was an X through it. Simpson says this shows that the voter didn't want to vote for Schaefer and wanted to vote for Simpson. Mr. Schaefer is here tonight, as he always usually is, and I've known Mr. Schaefer for years. And I can guarantee you that Mr. Schaefer would say, that voter was trying to doubly say, that's a vote for me. So what that comes down to is me saying you can't ascertain under those circumstances what the voter was trying to do, and I believe you should not count that vote. Then we have the issues of the in Ward 6 and 84, and Ward 6 was the issue of an election day voter registration, which I believe was done correctly. And in Precinct 84 was a name change situation, which I agree with the parties that that was done properly. If those two... Go ahead.
Can you clarify that Ward 2 and Ward 6 split 2 precincts?
Ward 6 was the, they were both grouped together in their arguments. Ward 6 was a same-day voters registration where they said the signature wasn't proper. I believe it was. And in Precinct 84, there was a name change situation. With regard to both of those, if you don't count them, again, we get into what is called proportionality reduction, because those matters aren't tied to those ballots, just like the affidavits.
Again, just for clarification, Precinct 65 and Precinct 84 are split between Ward 6 and Ward 2.
84 and 6?
84 and 65.
I know this is Ward Precinct 6 and 84 are the two in this case.
Precinct 6, okay,
If I've got my notes right,
got it.
they can tell you better than me.
Well, you're saying
No,
Ward
that's what
6.
the point I'm getting at is I believe they were done correctly, sufficiently, and that they should be no proportional reduction. In other words, I'm saying don't knock anything out on those two.
Mr. Hearing Officer, I'm trying to follow the sequence by which you're going through these challenge ballots, and in preparation for tonight's hearing, our Corporation Counsel kindly gave us the petitioner Gregory's challenges and on one sheet of paper and the respondent Simpson's challenges on another sheet of paper. And then thirdly, we also received a spreadsheet of all the challenges apparently.
That's correct.
So
I did too.
are you going in sequence in relation to any of these
What
documents?
I'm trying to do, Joe, is I was trying to simplify it, I was just trying to go through it very simply, saying these are 5 issues that I wanted to take care of first before I got to the initials and the affidavits.
Yeah, I'm not, you might have a good method, but I just can't find what you're talking about with the documents that we have, so that's.
Okay, well, in 3B, and it's the distinguished identifying marks on ballot for Gregory 8404. The damaged ballot was 87025 on page 3 of my opinion, and the 2 invalid affidavits of assisted voters is then on precincts 3 and 75 are there where I'm saying we should not count them. There we go. E, certificate on election day registered voter 06 and 84 are the ones I'm talking about, and the overvote is the first thing I talk about. Second thing I talk about on petitioners 2B. What I'm trying to do is the gist of these arguments for both parties is about the affidavits and the initials. If you want, I can go down these, but I, because of my recommendation, am recommending the same thing as to all affidavits and as to all initials, so that's why I didn't go by it one by one. Basically, what I'm saying is to give Gregory 2 votes on the damaged and the ink ballot, not give Simpson the vote in the over ballot, and not reduce anything for the certificate of election day registered voter and the name change. When you do that, it comes to 464, according to my recommendation, to 462. We then get to the question of all of the ballots with the issues of either having no initials, having numbers, or having some kind of markings or initials somewhere on the ballot, but not on the line in question where they're required to be. And then with regard to the affidavits, there's the issue of whether or not they were completed correctly with regard to people needing assistance. Over 30 years ago, I was very fortunate to become a judge. I was also very privileged and I'm honored that the Supreme Court picked me to mentor new judges over the years. And they still have me, to this date, go all over the state and counsel judges after they have received required performance evaluations. You're judges tonight. One of the things that I stressed with all new judges and judges that I counsel, you have to be fair. And of course, that's an easy thing to say, but how do you do that? And as a judge, how you become fair and show you're fair is you're consistent. When you become inconsistent, when you start treating matters and people differently under similarly situated situations, that's when people start perceiving you as unfair. So what I ask you tonight is to follow my recommendation and be consistent. You either count all the ballots about the initials or you don't count any of them. If you start saying there's an initial somewhere on a ballot, that's good enough. Is it good enough if it's an inch away? Is it 2 inches away? If it's on the back page, is it at the top? Is it at the bottom? Everybody knows precinct committeeman Fred is known by 62 and he writes 62 in there. Is that good enough? This is not a difficult task, folks, to write your initials where it says election judge initials. I mean, it's not a difficult task. We're not requiring people on the front lines, these good people that spend 15 hours on election day in these precincts to handle these matters, to ask them to do something like that. And I think if we're going to ask them to do something like that, they should do it. And they should do it right. And they should put their initials where they're supposed to be. Why? Because that prevents fraud. That's why that's there. Same thing with the affidavits. Do I want to tell you folks to say disabled voters, blind folks, possibly from the Mary Bryan homes, that we should throw out ballots because they weren't assisted correctly? Do I want to say that? No. But do I say it? Yes. And why do I say that? Again, these affidavits are important. If you're going to have somebody assisting somebody that's disabled, we want to make sure they're disabled and who it is that's helping them, and they're going in there and voting. We have to protect that sanctity of that voting booth. This is one of the few times where people can go in there with another person. And the only way you're going to do that is if you require that things are done correctly. That's why my recommendation is what it is. My recommendation is I want this city council to say, we will accept nothing less than excellence from our precinct committeemen, our election judges in the precincts when it comes to handling these matters. Our county clerk provides training for these folks. He gives them manuals, and they're available all day for a phone call or any assistance they need to come send somebody there to help them. There's no reason that things shouldn't have been done correctly in these cases. The resources are there to help these folks. But if you say, we're going to count them when there's some scribbling somewhere on a ballot, or we don't care because that's not right to try to say people that are disabled, their vote shouldn't count. What you're saying is to the election judges in the precincts, what you're saying then is, we don't care if you follow the rules. Do whatever you want. We're going to count the votes. We'll do it. Yeah. Kind of gives them free rein to do whatever they want. They know that the city council doesn't care. Yes, you do care, and I know you do. And I know you want all of your elections to be done correctly and all the correct votes to be counted that are marked correctly. And I believe if you do that and follow my recommendation, you will have, the law says, with regard to the affidavits, you have to do a proportional reduction. What that means is you got to do a lot of math. I went through the math 4 or 5 times. The attorneys did it again. I did it again, found decimal points and zeros and things, just one little bit off, or 1/10 of one vote, and I did it again. The law says that's what you got to do because these ballots, these affidavits aren't tied to those ballots. So you can't say, this affidavit's bad, we're throwing that ballot out. So the only thing you can do is take the total ballots, look at what everybody got, and then reduce it proportionally. Basically, it comes down to 2 point something that Mr. Gregory would lose if you do that, and 4 point something that Ms. Simpson would lose. But when you do all that, give Gregory the votes, the 2 votes I want to give him, not give Simpson her vote. Don't do any other reduction except for the affidavits. I come out to 459.3609 for Gregory and 459.7222 for Simpson, which means I'm recommending that Simpson win. Is that a crazy result? Yes. Does the public say, what the heck are you talking about, Neelick? Which they have said to me when they read in the paper what I have done. But what I've said to them and I've said to you tonight is that's what needs to be done to send a message, to a line in the sand, to say in Springfield City elections, we want them done right. We will have you follow the rules, ladies and gentlemen in the precincts. We will have you know that we will hold you accountable and that our elections will then be protected. Thank you and good luck to you.
Next, we'll have the petitioner will present the response to the recount hearing officer's report and recommend the findings. And then council members may ask questions to the petitioner's attorney at the conclusion of the presentation.
Thank you, Mayor Langfelder, members of the council, Judge Mielek, and opposing counsel. My name is Jim Morphew, and I, along with Greg Mordock, represent the petitioner in this matter, Willie Sean Gregory. At the outset, I'd like to thank a few people. First, County Clerk Don Gray and his staff, City Clerk Frank Lesko and his staff, and Mr. Zirkle and his staff, and opposing counsel for the professional manner in which this process has been conducted. The hearing officer's recommendations and findings declare that Ms. Simpson was elected by slightly more than a third of a vote. Mr. Gregory believes that when the law is properly applied to outstanding challenge ballots, he should be declared the winner of the Ward 2 aldermanic election by 1.639 votes. Mr. Gregory agrees with the hearing officer's report and recommendations in all respects, but one, and that is that Mr. Gregory believes that the hearing officer erred when he failed to count 2 votes for Gregory and 1 vote for Mr. Senor in Precinct 79, based upon his conclusion that a ballot has the judge's initials in the upper right-hand area of the ballot, and the placement of those initials on that ballot renders the ballot invalid. So I'll start with the uninitialed ballots. As I said, the council should accept the hearing officer's recommendation that ballots without initials not be counted. Ms. Simpson urges that none of the ballots, that all the uninitialed ballots should be counted. However, we must look to Supreme Court authority on this, and the Supreme Court has consistently held that applying the initialing requirement to ballots cast in the precinct is necessary to prevent the possibility of fraud and preserve the integrity of the election. The judge's initials are the only means by which an election official can identify and separate legally cast ballots from illegally cast ballots. It's designed to prevent fraud. Therefore, we believe that, as the hearing officer recommended, the ballots subject to challenge 8701 and 8705 should be sustained, and these ballots should not be counted in favor of Ms. Simpson. Likewise, there were 2 ballots where one cast for each candidate, where the vote or the ballot contained a number in the judge's initials line. The vote for Ms. Simpson, 2301, had the number 89 in that slot, and challenge 2304, which was a vote for Mr. Gregory, had the number 75. We agree that these ballots should be treated the same and not be counted for either candidate. However, as I said, we urge the council to reject the hearing officer's recommendation that a ballot bearing the judge's initials located to the right of the line designated for judge's initials not be counted. There are 3 ballots in Precinct 79 where the election judge initialed the ballot, but not on that line designated for the judge's initials. And if you haven't done so already, we would urge the council to examine these ballots and the challenge slips. They are challenges 79, 3, 4, and 6. And there's no question that the initials of election judge Pamela Sue Hart are on these ballots. And the challenge simply involves the location of those initials. Most importantly, Ms. Simpson cites no authority that imposes a requirement that the initials of an election judge must be in a particular place or a particular location on the ballot. And the reason for that, there is no authority. Ms. Simpson and the hearing officer asked this council to impose a requirement that does not exist. In fact, when you look at Ms. Simpson's arguments in their totality on uninitialed ballots, they really go from one extreme to the other. Basically, she says that no initials are required at all. You should still count those ballots. On the other hand, at the other extreme, she says if initials are required, they have to be precisely on that line for judges' initials. So we think that's a very inconsistent position. The initials on these 3 ballots are clearly visible, which allow the judges to determine that these ballots were validly issued by the election judge in that precinct. The fact that they're not precisely on the line is irrelevant. The initialing requirement and the purpose of that requirement, as enunciated by the Supreme Court, has been met. The judge can look at those ballots when they come out of the ballot box and determine that they were validly issued in that precinct. And for that reason, we think these 3 ballots should be counted, contrary to the recommendations of the hearing officer. With respect to distinguishing marks, we urge the council to accept the hearing officer's recommendation and overrule challenge 8404. Ms. Simpson alleges this ballot cast for Gregory should not be counted because it bears distinguishing marks. Votes on the ballot were marked with 2 different colors of ink in alternating races. The law is that to be a distinguishing mark that invalidates the ballot, the mark must be a deliberate marking by a voter, not made to indicate the voter's choice of candidates, and is effective as a mark by which the ballot may be distinguished. And we cite the Pullen case in our briefs, which is an Illinois Supreme Court decision. Pullen also says that the ballot should not be invalidated if it appears that the marks were placed on the ballot in an honest effort by the voter to indicate his or her choice of candidates. While completed in 2 colors of ink, there are no marks anywhere in this ballot at all, other than the marks to indicate the vote of this voter in the various candidates. Ms. Simpson in her arguments assume that this ballot was completed sequentially, that the person sat down and just filled in the ovals using 2 different pens in an attempt to distinguish the ballot. The council should keep in mind that this is an absentee ballot. This ballot was in the possession of the voter for an undetermined period of time. The voter could have voted a portion of the ballot at one time, put the ballot aside, came back and voted additional races, maybe did that on multiple occasions. So we believe that when you look at it in the context of an absentee ballot, and again, remembering the fact that the only marks in this ballot are there to indicate the votes of this voter, we think that this ballot passes muster and does not contain distinguishing marks. With respect to the overvote, we urge the council to accept the recommendation of the hearing officer and rule that the ballot subject to challenge 8716 and 8717, 2 challenges to 1 ballot, contain an overvote for Ward 2 alderman and should not be counted for any candidate. As the hearing officer described, both ovals for Simpson and Schaefer are filled, and there was an X through the Schaefer oval. On election night, this ballot was not counted by the tabulation equipment because it was read by the machine as an overvote. The statute and case law state that the intent of the voter must be clearly ascertainable from the face of the ballot for this vote to be counted for any candidate. Ms. Simpson engages in speculation when arguing that this voter first voted for Schaefer, then changed his or her mind or corrected an error, and then voted for Simpson, and attempted to cancel the Schaefer vote with an X through the Schaefer oval. However, the opposite could be true. The voter could have voted for Simpson, decided to vote for Schaefer, and then reinforced or emphasized that vote with the X over the Schaefer oval. The point is, the clear intent of this voter cannot be ascertained on this ballot, and to attempt to determine the voter's intent would be to engage in impermissible speculation into the mind of that voter. It's also noteworthy that the electronic voting machines in Sangamon County are programmed to notify the voter if he or she casts an overvote in a particular race. The machine beeps and presents the voter with 2 options. 1, return ballot. If you press that button, the ballot is returned to you. You can go back and get a new ballot and revote. Or you can say, press the button that says count as marked. In that case, the ballot goes into the machine. So we would argue that based on this technology, the most plausible intent that should be assigned to this voter is his or her desire to leave this as an overvoted ballot in the Ward 2 aldermanic race. With respect to the damaged ballot, the council should accept the hearing officer's recommendation and overrule challenge 87-25, which challenges the process by which a damaged ballot was remade in the county clerk's office. This was a mail-in ballot received at the county clerk's office. It was damaged to the extent that it could not be accepted by the voting machine. Ms. Simpson argues that the damaged ballot should have been marked damaged ballot and the new ballot marked duplicate damaged ballot along with sequential numbering. And for that purpose, Ms. Simpson relies upon the Larson case, which we believe is distinguishable here. In Larson, there were 2 damaged ballots that had to be remade, and there was no numbering on any of the ballots. Here, there was only 1 ballot that was damaged in this precinct. The word remade was put on instead of duplicate and duplicate damaged ballot. It was initialed by 2 election judges. It was remade by those judges with 1 reading the votes on the damaged ballot and the other recording those votes. Then that process was verified, the votes were verified, and the judges initialed both ballots. So we feel that this meets the requirements and that the integrity of this vote was not compromised by that process. Really, the only deviation was that the word remade instead of damaged duplicate was placed on the ballot. With respect to the assisted voter affidavits, we urge this council to accept the hearing officer's recommendation to invalidate the 11 assisted voting affidavits in Precinct 87 and proportionally reduce the votes for each candidate in that precinct. The requirements of the election code when voters receive assistance is very clear. One, the voter must state under oath that he or she requires assistance to vote and the reason that assistance is needed. Number two, the person providing the assistance must sign an oath swearing not to influence the voter's choice of candidates. And we argue that these are mandatory requirements designed to preserve the integrity of the election. As the hearing officer alluded to, these voters might be taken advantage of, and you want to at least have the person assisting under oath in the event that that person compromises that ballot against the wishes of the voter. In these affidavits, when you review them, the voter never states a reason for requiring assistance or subscribes to a required oath. Moreover, there's no oath given by the person assisting the voter. And this oath, and it's right on the form, subjects the person rendering assistance to the penalties in Article 29 of the Election Code, which include the penalty of perjury. None of the parties subscribe to the oaths required by this section of the Election Code. And these oaths are mandatory because they activate the perjury provisions of the Election Code. As you saw from the record, Ms. Simpson attempted to rehabilitate these affidavits with post-election affidavits. We argue and cite cases in our briefs that disallow post-election testimony to rectify and cure an election day defect. We rely upon the Qualkenbush and Chicho cases, which hold that filling out the affidavit stating the voter's disability and the need for assistance is a mandatory requirement when the form is provided by the election authority for this purpose. Last two items, the certificate of election day registered voter, which was upheld by Judge Mielek. The judge or the voter failed to sign a certificate of election day, failed to sign a certificate. She signed the certificate, but then when she received the ballot, she did not sign a second time. The election judge did not challenge her right to vote. The judge initialed and spindled the application, and this is very similar to the situation, or one of the many situations in the Pullen case, where the Supreme Court said that because a voter failed to sign an application for ballot at the polling place, they were not going to discount or reduce those votes. The affidavit of name change, here the voter who had changed her name properly completed the affidavit stating under oath that she was the same person under her former name. There was a signature on the form as a witness, but the statute itself does not require a supporting affidavit, so the requirements of the election code were met. So, ladies and gentlemen of the council, for these reasons, we would encourage the city council to adopt the hearing officer's recommendations in total, except with respect to the three ballots in Precinct 79, which are initialed in the upper right-hand corner. We feel those ballots are properly initialed, meet the requirements of the election code, and should be counted. Thank you very much.
A point of order, Mr. Mayor. Prior to this hearing, we received a proposed format that we would follow for this hearing, and the proposed format says that the council members may ask questions to the petitioner, at each phase of this hearing. So the question is that what the parties agreed to? Because if so, then we're allowed to ask questions now. Is that correct?
Yes, that is correct.
Okay, thank you.
Alderman Donlin.
So we are allowed to ask questions now? All right,
Yep.
just making clear.
Thank you.
I have an affinity for the election code and rules, and especially it matters as important as the election. I think the will of the citizens, I think everybody in this room agrees that it should be followed, and it is of utmost importance in this country and in the world. And that being said, I'm also been taught by my mother that mother and father how important common sense law or common sense is. And when the election code is not specific, I think the natural progression is to go to common sense law. So one of the items that you mentioned, Counselor, dealt with the ballots that have the initials up in the upper right-hand corner instead of on the specific line for the judges. It's literally maybe an inch and a quarter away. In your opinion, just simply stated, in your opinion, does the election code specifically require the initials to be on that line?
There's nothing in the election code or case law that we've been able to find that specifies the location of the initials. The purpose of the initials is to verify that this judge, that a judge of election in that precinct issued that ballot, so that when they open the ballot box at the end of the night, you go through the ballots, and any ballot that is not initialed is supposed to be pulled out of the stack, okay? When you look at that ballot, you know that that ballot was issued by Pamela Sue Hart. And regardless of whether the fact it was on the line or an inch over or 2 inches over from the line, we think is immaterial when you consider the purpose of that requirement. And I would say that if there was authority to count that or to not count that ballot because of the location of the initials, they would have been cited in Ms. Simpson's briefs, and there were no such cases cited.
Thank you.
Mr. Mayor?
Yes, Alderwoman Conley.
So just to follow up on the point that Jim made, does the election code actually require initials?
Yes, the election code requires initials.
So-
And at least 3 Supreme Court cases in the 90s reaffirmed that requirement.
Thank you.
Mr. Mayor?
Alderman McMiniman.
Thank you, Mr. Morphew, for your presentation. So in summary, you agree entirely with the hearing officer's report, except for those 3 ballots that involve the judge's initials being close to, but not exactly on a line that refers to where the initials
That's
could
correct.
be placed.
That's correct.
And that election judge you indicated had the name of Pam Sue Hart, is that correct?
Pamela Sue Hart, and the initials PSH are on the ballot.
And during the course of the hearings that the hearing officer conducted, did anyone ask that election judge to appear at the hearing to confirm or deny that those initials were hers?
There were no hearings before the hearing officer in terms of argument or evidentiary hearings. If you look at, I think it's Exhibit 1 to our, which in the reply to the hearing officer, basically during the recount process, when this issue arose, we took a ballot initialed by Pamela Sue Hart and that was on the line and agreed that that was a template that we should include in the record. We also included the judge's oath that they fill out on Election Day, and I believe her expense report. And it shows that Pamela Sue Hart is the judge in that precinct that initialed these ballots. I don't think there's any dispute as to that.
So are there any other ballots that include the initials of PSH?
Yes, there are several others. And in fact, as I said, one of them is included as an exhibit just by way of example in our briefs.
In any of those other ballots, was the PSH initials placed on the line that says the judge's initials?
Yes.
And when you compare those 2 ballots where the initials were placed on the line that says judge's initials and compare that ballot or those ballots to these 3 ballots where the judge's initials were placed a quarter of an inch or an inch and a quarter away, do the initials look the same?
To me, they do, yes.
Is it too late to ask Pamela Sue Hart to come to this hearing? Or I guess we've got it scheduled for Thursday night to confirm whether or not she believes that those are her initials.
Is that a dispute? Is anybody disputing that?
I don't know that there's any dispute that those are her initials.
I mean, I looked at the ballots that were provided, and the initials look exactly the same.
All right. Well, thank you very much. I just wanted to see if there's any corroboration, and it sounds like there is corroborating evidence. Thank you.
Thank you.
Alderman Redpath.
So, Counselor, directing my comments to the judge, his comments were about how we follow the rules and how look at the things that we have to look at, especially on how the initialing's going in there. One of my concerns is if it's not in state statute and what are the rules, can I refer to the county clerk to ask him what the procedures are on how these people are trained? Can I ask that question, Corporation Counsel?
Sure.
And that may be something even the parties, but yes, you certainly may ask the elected official. He's actually the election official.
State your name and title, we'd appreciate it.
So could you enlighten us about how people trained? And it goes back to the question that Alderman McMinimum had about there's other initials with this judge's initials on it, but they were all in the right place. But these 3 ballots, they were not. So can you tell us what the procedure is for how people are trained and how that works?
Sure. So it's Don Gray, and I'm Sangamon County Clerk, and thank you for the question. Yes, we thoroughly train election judges to every aspect to what's important to making sure that elections go well, that they are followed by law, and we go at length over a long period of time to do that. Election judges post an even year primary are required by law to be certified as election judges, and part of that certification process is a mandatory class of which Sangamon County provides. You have to sign up, you come, and we walk you through every element of Election Day of what they would be responsible for and the roles in which they would play on Election Day. And certainly one of those roles is the validation or the activation of the ballot, which would be initialing the ballot. And we instruct them to initial the ballot as required by law and to initial the ballot on that line.
So that's specific.
That is specifically trained in the certification training of judges. We also have refresher courses. So if we're not in a certification year, we offer refresher courses, and routinely election judges take upon that opportunity to refresh themselves. You need to keep in mind, election judges are serving a 15-hour day, maximum of twice a year at most. So it does take some refreshing to them to the procedures. Election laws, we have learned from this experience, has a lot of moving things that need to be done, that need to be accounted for and taken care of. So in addition to that, we continue to keep instructing them through different means. We have a manual that's available. As we get closer to elections, we continue to articulate the important points. There have been videos of which I have cut and put together that we've sent out to folks, and we're always stressing what those important parts are. But clearly initialing the ballot, which activates that ballot, is a very important part of that job, and it needs to be in the right place. And there are 2 additional pieces of why, from the election authority's perspective, that it's important that it's in that area. Second of all, it's the deterrence of fraud. We've talked about fraud and not having foreign ballots find its way inside to the tabulator. And the initials on that ballot in that spot are important because the judge that works the tabulator on Election Day is looking for those initials before they go through the tabulator to make sure that we're not having any foreign ballots submitted into the tabulator, or any additional ballots that could have been stuffed in at any point. Thirdly, when polls close, election judges need to account for every ballot that had been cast that evening. Here in Sangamon County, we do have a number of precincts that are in one polling place. And we distinguish the difference of those ballots to each precinct by different color pens, of which election judge is initial that ballot at the top. And in election evening, when polls close, they open up that tabulator and they separate all those ballots amongst themselves so they can do their part to account for every ballot cast before they can pack up all the official products and get back the official data card within the tabulator for us to upload to the public that evening. So those are the 3 main points of why we do that. It's extensive training. And of course, as Judge Mielek made reference to, in every piece of what we do and what we provide, if there's anything ever in doubt, they are instructed to call the election authority. We have professional staff that are fully briefed and trained on every part of this, long-tenured professional staff in Sangamon County, and we have a lot of them on call during the day to be able to help with that process. There's also what we call a runner that's responsible for a route of polling places that is routinely visiting each precinct throughout the day, of which they're handling any issues or taking any questions that they might have of these election judges, and they often do get many of those questions. So there are a lot of different avenues and routes for them to be able to ask questions if there's anything in doubt.
Mr. Mayor?
Yep, Alderman McMillan and
Mr. Gray,
Alderwoman Conley.
you're saying that the initials must be on that line. Now, that's your personal opinion. We don't find that personal opinion anywhere in statute law, nor do we find that anywhere in case law. Is that correct?
Not a
Based on
personal
what I've heard
opinion, it's
so
also
far?
the opinion of the Illinois State Board of Elections. They train and articulate to the elections judges' initials being on that line.
Well, is it they should be on that line or they must be on that line?
I don't have the specifics to
Well,
exactly
you
how it's
just-
spelled out in
Well,
statute.
you just said that the
and I'm not sure if
State
it's
Board of Elections backs you up, but we got to be
Yeah.
very clear about what we're talking about here, Mr. Gray. So the statute does not indicate that the initials must be anywhere particular on the ballot.
Well,
and there's no case law on the point.
And again, I don't know if it's a shall or may or must as specifically written in
Makes a big
statute.
difference, Mr. Gray.
But it's required. It's required to have to be initial in order to activate that ballot, including the State Board of
I think we
Elections.
all agree that there has to be initials there. We all agree that.
Okay.
But Mr. Mayor, before Alderman McMenamin interrupted, I was asking him how they train the people, and he told us that the training for these people specifically says they need to be in that box.
I don't think anyone interrupted anybody. We're just talking at the same time.
Let's just stick to.
I'm sorry, I
We don't need
misunderstood
to
it.
characterize anybody, Mr.
Alderwoman Conley.
Redpath.
Alderwoman Conley.
Thank you. So Clerk, I have a question, just a point of clarification to make sure I've got the process correct.
Of course.
When I as a voter go in to get my ballot,
Yes.
I sign, the judge signs my ballot at the table.
Yes.
I make my choices, and then, as you said, when I go to feed my ballot into the
Yes.
box, there's a judge standing right there
That's correct.
to check to see that it's been initialed.
That's correct.
So at that point, I've had 2 trained people look at my ballot to ensure
Right.
that it's been initialed by an election judge.
That is correct.
And as you said, there are a significant amount of resources, so should the person standing at the feeder, and I'm sorry, I'm not going to get my terminology correct, but that would be an appropriate point to say, this signature is not on the line.
Yeah, that's what they're supposed to do.
Okay, so in both instances, the ballots were allowed to go through without that, as if that check had been made and the initials were properly
Yeah.
made.
That did happen.
Okay, and then one more point of clarification. You said the training is done on even years?
That's correct.
So for the election judges for the spring 19 election, they had last gone through the refresher training a year prior, is that correct?
No, there's a refresher course that's offered every cycle. So even
Okay.
to the buildup of the spring consolidated elections, there would be many opportunities for them to take an additional refresher course to the responsibilities of
Okay, but the
election judge.
refresher course isn't mandatory, correct?
It's not mandatory, no.
So, but the mandatory training would have been done a year prior to
That
the
is
election?
correct. That is a
Okay,
mandatory certified,
thank you.
yes, training.
Alderwoman DeCenso.
Thank you. I've taken the training to be an election judge. It is a lengthy training. It is very specific. And I have voted both early, which I did this year, and there was no one standing at the machine to accept my ballot. I've poll watched on Election Day. I've done, anything you can do on Election Day, I've done it before being a candidate myself. And there are many times where there's no one standing at the feeder or at the machine accepting the ballots and examining them, because that's why you have the sleeve, is to protect your ballot.
That's correct.
As it's being fed in. And then you get the, beep and says your vote has been counted, and that's that. So this myth that someone is sitting there at the machine looking at your ballot to make sure that it's been initialed is completely false.
I've actually always had someone there.
I've never
Precinct
had
80
someone
does a
there.
good job.
Yeah.
Yeah, they're supposed to be. I mean, there should be a judge that's working the tabulator. It's a prescribed
There might be
role.
someone standing there, but they're, chatting with you,
Yeah.
or, how's your day, or,
Right.
happy voting, whatever.
One question I would have is, were any votes not counted that were initialed? I mean, we have 3 contested ballots. Are there some that weren't counted that were initialed in the wrong spot, were not counted?
I'm not quite sure if I understand the question, Mayor. So on election eve, when
We had 3 contested ballots.
Correct.
Because the initials were in the wrong spot. Were there any ballots that went through or that were not counted that had initials in the wrong spot that were not contested?
when were they counted? Are you talking on election day during the early vote process?
Just through
by
the
mail?
recount process.
I'm not familiar.
Because I know both sides. I mean, I guess both sides should answer this because you contested 3 ballots. Were there particular ballots that were not contested that might have had initials in a different spot?
Does anyone know?
Are there any other, Mayor, I believe those are the only 3 ballots with the initials not on the line.
Okay.
And to my knowledge, those 3 ballots were processed and counted by the machine. That's my understanding.
Well, that's
Right,
pretty
so
good.
the electronic tabulators are not going to take into account if there is an initialing or not. They're going to read the ovals that have been darkened in that evening.
Okay. And then I have one more question for the council. I know you contested the one with regards to the Simpson vote. Is there a reason why you contested that? If if you feel that the initials anywhere on there should be counted, is there a reason you contested that?
Mayor, are you referring to the Senor vote?
Well, it's it's number 079-006, I believe,
Yes.
or 079-007.
So let me explain what this process was like. We're sitting there at the county clerk's office, and we're all at a long table, and the election officials are handling ballots. They put the ballot in front of you. You have to make a split-second decision whether you want to challenge that ballot or not. So at that point in time, we did challenge the ballot. We withdrew that challenge, and basically, after researching the law, determined that those votes should be counted, that there's no authority stating where the initialing has to occur, and the fact that there's a line for the initials certainly aids the judge in placing them in a visible place. But again, these are merely to the right of that line. And when you examine the purpose of that requirement to verify that that ballot was properly issued in that precinct, I don't understand why it would matter if the initials are on the line or just to the right of the line. And just to add one more point, the uninitialed ballots that the hearing officer says should not be counted, those were all counted on election night as well.
Okay, thank you. Any other questions? Thank you very much.
Thank you.
So next we'll hear from the respondents. Counsel, if you please introduce yourself, we'd appreciate it.
Thank you. May it please the City Council, Mayor, Judge Mielek, opposing counsel. I am Alan Yao, and I'm here on behalf of Gail Simpson, and my associate Court Brown is also here today. We do appreciate the opportunity we have to express to you our view of the evidence in this matter and the recommendations of Judge Mielek. While we do concur in Judge Mielek's recommendation that Gail Simpson should be declared the winner of the April 2nd election, we believe, however, that her margin of victory should be larger than what he has indicated based on the various arguments that we have made in this case. But it's important, although we agree with the ultimate decision reached by the hearing officer, it's important for me to address several of these issues that impact the ballots. We have had already quite a bit of discussion regarding the initial requirement. And yes, it has been the position of Gail Simpson that the voters are entitled to be heard. The votes cast on those ballots, whether they were for her, for Mr. Gregory, or one of the other 2 candidates, they should be heard. And their votes should not be discounted merely because an election judge failed to perform a ministerial duty, which, quite frankly, the initialing requirement is. Now, we are cognizant, and we have all along acknowledged that there is case precedent out there that the initialing requirement is mandatory. We have argued, though, and urged the City Council to take a stand for the voter here, and also adopt the language of former Illinois Supreme Court Justice Freeman, who indicated that the mandatory construction is an unconstitutional burden that disenfranchises an innocent qualified voter based on the failure of an election judge. And let's be clear, what we're dealing with here are inadvertent mistakes by the election judges. There's no allegation of fraud here. There's no indication that on any of these ballots that the votes for that particular candidate were not what the voter intended by any means. This is sort of akin to the sports adage that let the players decide the outcome of the contest, not the referees. So to put it in our parlance, the election should be decided by the voters, not ministerial errors of election judges. Now, we understand that the recount hearing officer found that the initial requirement is mandatory. And we have also indicated that, well, if that's the conclusion reached by the city council, then the city council needs to apply that consistently. And what do I mean by that? That means all of the ballots that are at issue regarding the initialing requirements need to be treated the same way. In this particular case, if we're saying it's mandatory, then all of the ballots need to be held invalid, and that includes the 2 ballots for Mr. Gregory, which are really kind of at the heart of what Mr. Morphew was talking about a few minutes ago. They believe, they concur in the hearing officer's decision, but for these 2 particular ballots. Now, council argues that there's no precedent requiring that the initials be in the center of the ballot. However, council does not cite any cases holding that election judges can place their initials outside the area designated for them on the ballot or anywhere they please. The ballots at issue have a clearly defined area for the insertion of the election judge's initials. And the ballots at issue in Simpson Challenges 79-3 and 79-4 do not have the initials of an election judge in the space provided for them. If the purpose of requiring an election judge's initials be placed on the ballot is to protect and safeguard the ballot and the integrity of the election, allowing a judge's initials to appear anywhere other than the designated location on the ballot would undermine the importance of the requirement and could lead to attempts by voters to forge the initials of election judges anywhere on the ballot. Allowing election judges to initial anywhere on the ballot would not allow for the immediate recognition of a legally cast ballot, thereby undermining the policy of ensuring ballots' validity. And the county clerk recently just spoke to the fact that they train the election judges to put those initials in that spot, the designated spot. And it is designated, all right? It's not like a blank space. It actually says judge's initials. Well, if you're going to have that requirement, then the judges need to put it there. So we know, in fact, that that ballot was properly signed by an election judge. And it also helps during the counting process that they go through at the precinct that evening. So if they're going through there trying to see if these votes are, have they been properly initialed? Well, if they're they're looking in that particular designated spot. So that's why it's important to prevent fraud, as the hearing officer indicated to you, and I believe Mr. Gray indicated to you. The purpose is to prevent fraud. So if the city council determines that the initialing requirement is mandatory, in conformance with the recount hearing officer's determination, then it must also accept the hearing officer's recommendation that it be applied consistently. If the voter is to be disenfranchised due to the mistake of an election judge, such disenfranchisement must be done in a consistent manner. Accordingly, Simpson Challenges 79-3 and 79-4 should be sustained as recommended by the hearing officer. This would result in 2 votes not being counted for Mr. Gregory. Now, going a little bit out of order in what I had planned, but if we're going to have the strict construction here that the initials must be, the initialing requirement is mandatory, let's think about the damaged ballot issue. This is Simpson Challenge 87-25. And with regards to this particular challenge, we have a statute that's been cited in the materials that clearly says that the damaged ballot, during that process, it must be labeled damaged ballot. And the remade ballot must be referenced as, wrote on, duplicate damaged ballot. And they must have the numbers on them. For example, damaged ballot 1, duplicate ballot 2, they're supposed to be in there. The statute says that clearly, it provides the language. The Larson case held that, and that's a 4th District case, we're in the 4th District, held that this is a mandatory requirement. So if we're going to strictly construe these rules and the requirements of the election code, then we need to be consistent here as well. This was a damaged ballot. Now, with regards to this particular ballot, it is a vote for Mr. Gregory. And as I said, it doesn't contain the correct language or the numbers. Now, opposing counsel argues, well, this is really not a problem because there was only one damaged ballot. Well, that was the luck of the draw, wasn't it? Because this damaged ballot was remade on election night. What would have occurred if other ballots would have arrived several days later that had been properly postmarked? And they needed to be remade, all right? So you can't, in a sense, pick and choose here or say, well, after the fact, it was okay. Further, they dispute and argue that you should not consider the affidavits from the Mary Bryant home residents and the staff. Well, what do they use to support their theory on the duplicate ballot issue? They rely upon an affidavit from a county clerk. So not from the county clerk, but of an officer in the county clerk's office. So if we're going to be consistent, if you're going to consider that affidavit for this purpose, then you need to consider the affidavits of the Mary Bryant residents and the staff that work there. Now, with regards to a couple of matters, with regard specifically the overvote issue, we believe that this is a classic case of the voter changing his mind. And that, I believe, is clearly shown in the documents before you. If you look at the ballot in question, and this is Gregory Challenge 8716, it clearly shows that in all the races, it has the circle filled in. All right, he's consistent, the voter, he or she is consistent here. And then at some point, when they get to this race, there's a vote for Mr. Schaefer, but then it has a big X through it. And then there's the vote for Gail Simpson. It's not improper speculation. The election code clearly provides that you have the ability to look at that ballot and make the determination. The election code provides that a vote should be counted if the designated area for casting a vote for a particular ballot position on the ballot sheet contains some other type of mark that indicates the clearly ascertainable intent of the voter to vote based on the totality of the circumstances, including but not limited to any pattern or frequency of marks on other ballot positions from the same ballot sheet. We urge you to find that this overvote is not an overvote, and it's actually a vote for Gail Simpson. We also believe that with regards to the affidavits, which there are quite a few affidavits of assisted voter that we have to deal with here. But it's important to note that the election code provision regarding this does not say if it's not properly done, the votes are invalid or the ballot's invalid. It doesn't say that. And if you read the Poland decision, when the statute does not expressly state that failure to comply invalidates that ballot, all right, it's not mandatory, okay? And I would submit to you that when you look at the affidavits of assisted voter here and the accompanying application to vote that's right next to them, you will see that the signature of the voter appears on both documents. The signature of the election judge appears on that document. And for 9 out of the 10 of the Mary Bryant residents, the signature of the person that assisted them is on it. Now, I consent and I agree that those signatures were not placed in the appropriate places, okay? But they're there, okay? They are there. And so that also then, opposing counsel argues, well, these affidavits aren't good enough because their signatures are not in the appropriate locations. But, those election judge initials don't have to be in that location. We have to be consistent here. We believe that from looking at the affidavits, it's clear that the statutory requirements were substantially complied with. There can be no dispute here that the people involved at the Mary Bryant home were blind. They resided at the home. They appeared before the election judges. Those election judges had the ability, if they did not believe that they qualified to vote with assistance, they could have challenged them. They did not challenge them. Once again, the voter's signature does appear on the affidavit, albeit not in the right place, okay? But they were blind residents who were apparently trying to do the best they could based on the directions they were given by the election official. Based on the records that we have submitted to you and the arguments, we believe the actual vote count is 468 in favor of Gail Simpson, and Mr. Gregory has 463. We believe there's a 5-vote margin here based on the pleadings that are before you. However, if you determine that the recount hearing officer's recommendations should be followed in their entirety, then we believe that Gail Simpson's margin of victory should actually be .3612 rather than .361. There was just a little bit of a mathematical issue there, which we pointed out in our reply brief. In conclusion, Gail Simpson prays that the Springfield City Council will find and declare she is lawfully elected and seated Alderman of Ward 2, Springfield, Sangamon County, Illinois. One other issue. To avoid the appearance of favoritism and impropriety, I respectfully request that Alderwoman Doris Turner, who is the chairperson of the Sangamon County Democratic Party, which is supporting Mr. Gregory in this case, recuse herself from further deliberations and that she not vote on this matter. Thank you.
Any questions?
Questions?
Alderman McMenamin.
Thank you for sir, what's your name again?
Alan Yao.
Alan Yao, thank you for your presentation. Regarding the Mary Bryant affidavits,
yes, sir,
from Precinct 87,
yes, sir,
were there 12 of those?
There were actually 11 ballots cast there. 10 of those were residents of the home.
And were the affidavits all incorrectly filled out in the same way?
I believe so. I mean, the top part of it oftentimes did not have much information for the name of the person, that type of thing. But then below them, you would then have the signature of the person that gave assistance to the party, at least on 9 out of 10 of those, okay? And then you would have the election judge had signed below that. In other words, that he had, I guess, meaning to represent that he had observed that person sign that affidavit.
So you represented that, maybe it'd be easier, Mr. Mayor, that we obtain copies of the Mary Bryant invalid affidavits for deliberation purposes. I don't know, we all have that at our desk tonight, so it'd be helpful if we could have those. But you represented that there was a missing, the signature was not in the right place, but I think you're also saying there are other defects with those affidavits. Is that correct, Mr. Yao?
Well, I think Mr. Morphew would argue more that there's more defects in these affidavits. But with regards to the affidavits in question, there is a question as to whether or not the signature of the voter, for example, is located in the correct place. For one of the affidavits, for example, for a Kim Martini, in the signature line where she would sign as the voter, it says signature voter, all right? It appears to have the signature of the person that assisted her, okay? But the voter signed further down on the, in the document in a place where the person giving assistance should have signed, So.
Okay, thank you.
Alderwoman Conley.
Thank you. And again, thank you for all of this, the detail and the level of depth in your conversation about this. I do have, and I'm sorry, I can't pull this up on this screen very quickly, but I did look at the affidavits, and I think the judge made a very valid point that there is a difference, there's an implication with the incurring the risk of perjury. And there's a very specific portion of those affidavits where you check and sign, and that's where the perjury language is contained. And in my recollection of looking at those affidavits, I don't believe any of those portions of the affidavits were completed. And that's my concern, is that, and I'm not trying to cast any aspersions on the people who do help with this, and I certainly take this very seriously, that people who are visually impaired should be able to vote in as discreet and confidential a manner as possible. My concern here, and this is where I would ask kind of your thoughts on this, none of those oaths that say, I at the risk of perjury, I'm doing what this voter is telling me what to do. Were any of those completed?
By the individuals giving assistance, it does not appear to be. All right. But with what actually what's interesting is that the oath does not say necessarily specifically under threat of perjury. Okay, it doesn't say that. It says under the penalties described in Article 29 of the Election Code.
And what does Article 29 describe?
Well, it is basically some criminal penalties.
Which would include perjury?
Probably, but it doesn't say perjury. But what's also important is that that statute and the 29 doesn't say about invalidating the ballot. But to get to your question, no,
right.
These were not, the signature of the person giving assistance is not on the line. It's a signature of the voter, all right? And when you look at these, there's an X by a lot of these signature lines. I can only suppose that perhaps those were put there maybe by the election judge, okay? And if you read the affidavits, I know there's a dispute as to whether or not you should consider them or not. But once again, if you consider the affidavit coming from the county clerk's office, you should consider these as well. But based on those affidavits, the people that were giving assistance, in their affidavits state they signed where they were where the election official told them to sign. Okay.
Right, and my concern is not with the people actually casting the ballot. Actually, my concern very deeply is with the people casting the ballots, and my concern here is that the person who was physically marking the ballot for them, it's more than just a signature. There's check boxes involved, and that's where I understand under penalty of law that this is a very important sacred thing that I'm doing for someone. I have to tell you, this entire process has gotten me extraordinarily patriotic, and it's been very difficult because I have a high level of respect for both candidates who are in the situation. But I think at this point, my main goal and all the entire thrust of my questions are going to be, how do we ensure that the integrity of the voting process is maintained, that we are, as best as possible, reflecting voter intent. And in this case, none of those were filled out to say, I'm checking here to say that I am going to do exactly what this voter intends. Is that correct?
That's correct. The only thing as far as trying to give you some solace in this, in that regard, is two things. One, you have on these documents the signatures of the voter, of the person giving the assistance, and of the election judge. So that should give you some solace to believe, okay, wait a minute, we actually have someone that's disabled and entitled to vote with assistance, all right? And once again, these signatures are on there, not in the right designations, right place. If you consider the affidavits from the staff members that assisted these individuals, they state under oath in those affidavits that they filled out the affidavits they filled out the ballots as directed by the voter, okay? And in fact, in the affidavits of the actual voters, they set forth that we asked them to serve and assist us in this.
Alderman Redpath?
Counselor, you're contradicting your argument on the initial part of the initialing the ballots compared to the affidavits that you're talking about. If we're going to say they can't bring in the initial ballots, why would we think that if they made mistakes on the affidavits that we would let those in?
Well, a couple of different things on that with regards to, once again, the initialing requirement. There's one aspect, all right, and if you hold that that's mandatory, okay, then there is a designated spot on that. And my argument is, look, if there's a designated spot, okay, their argument is that it doesn't matter about the designated. In other words, I'm trying to show their inconsistency here. But we have two different things obviously going on. You have the ballot on one issue, and then you have these affidavits, which is a totally different document. And I would argue to you that the requirement of this assisted affidavit is directory and not mandatory. In our arguments before the City Council, we have stressed repeatedly, probably more than you like, that this is a directory requirement. The statute does not say that if you fail to do this, that's an invalid ballot. Now, that's not a license for people to short shrift this and not do their best and substantially comply or to commit fraud. I guess I'd stress to you, based on the documents you have in front of you, that you can find that there's no fraud here, that there was an intent to comply with the statute, not perfectly, but the attempt to comply, and that these voters at the Mary Bryant home should not be disenfranchised.
Well, and no one wants to disenfranchise the voters from Mary Bryant, obviously, but the bottom line is that we're either going to follow all the rules the way they are, and as the judge said, we have to make that determination. And,
absolutely.
And so if we're content on throwing out the ballots that were initialed in the wrong spot, I just disagree with you. I understand your argument, but I disagree with you. If we're going to throw out those, we got to throw out these. Okay.
Appreciate your comments.
Alderman Hanauer.
Thank you, Mayor. Yeah, I've got one of these pulled up on my computer, and you can find these at the clerk's website, just to let you know. I kind of agree with Alderman Redpath that if we're going to be strict with the rules, we got to be strict with the rules. And these, these affidavits a lot of them aren't filled out. And you are correct. Some places they got the judge signed it one place and the voter signed it one place. If we say there's nothing to say that we can't say, well, they signed the form. It may not be in all the spots they're supposed to sign it, but they signed it one time. And I have a hard time with that. When you go to a home loan or something, you got to sign a bunch of different places, right? And I agree with the judge that the rules are there, the lines are there for a reason, and if we're going to apply it towards the initials, then we got to apply it to this. And I don't agree with your argument on that, but I do agree that if we're going to be strict about where the initials fall, we got to be strict with these two.
Thank you for your.
Yeah, point of clarification. I think what he's saying is if you're going to count the ones in dispute, say we go the opposite direction, you're counting the initials on the ballot, then you're saying you should count the affidavits. Is that your argument?
Yeah, that would be, yeah.
I don't disagree
And then,
with that.
but if you're going to, like you said, if you're going to do the other, none of it counts, all of it counts, all of it counts.
Yeah, it's one or the other because
Right. Can't pick
we're
and
just
choose.
saying we're just going to allow them to put their signature somewhere on the form,
Right.
then it's valid.
Alderman Donlin?
Thank you, Mayor. Again, reiterate the statement I made earlier about the importance of rules in these proceedings. Do the rules specifically state that this document has to be filled out for the assisted voting? Well, in its entirety. And what I heard earlier is that it does say that. And on and what I heard earlier is on the three initial ballots in question, that it doesn't the statute doesn't specifically say it has to be on that line. So they're not, it's not apples to apples. They're completely different. Having a document signed by, I understand why that's in the statute. And so what, in your interpretation, what does the statute say? Does it say that it has to be filled out?
A couple of things with regards to the statute. One, it does not prescribe the form of the affidavit to be provided. So in other words, the General Assembly has not provided the form. Whereas like with regards to the, I believe the application for absentee ballot, which is discussed at length in their briefs, all right, this particular statute does not require that, nor does the requirement, nor does it, as I said previously, require that if you don't comply with it, it's out. Like the initialing requirement in the statute talks about if it's not initialed, you don't count that. Okay. Now, the statute does say, though, that in order to get the assistance, you do have to, under oath, state that you have a disability, okay, and that you sign. You know, you either have a disability or you don't speak and read the English language, okay, and that you would sign under oath for that, okay, and it does also require the person that gives assistance to do that, okay, to sign off on the oath saying, I provided the assistance, I did not, you know, I did what the voter asked me to do, paraphrasing. So it does put it in there, but it doesn't provide the specific form for doing that.
What does the case law say? This is, I heard earlier that it has been tried before.
Well, that's not so clear. They cite cases regarding absentee ballot applications, which is different than what we're doing here, okay? And so the cases, in my view, are not so clear that it's automatically that this is a mandatory. And we distinguish, there's one case, I believe from 1920 or so, that we have distinguished in, you know, in our briefs. But once again, the statute doesn't say that it's mandatory, doesn't say that the ballot is automatically invalidated if you don't follow the procedures. And from our viewpoint, based on also the argument, is that the courts have also held, even if it's a mandatory requirement, if there's substantial compliance, that is sufficient. And our argument with regards to these particular affidavits is that there is substantial compliance here. Not perfect compliance, obviously, but substantial compliance.
Alderwoman DeSenzo.
But to be clear, the Mary Bryant home ballots were voided.
Well, that's the recommendation,
That's the recommendation
of the hearing officer, yes.
So we're not talking, you would like them to be included?
Absolutely.
Okay, but in the current vote total given by the judge, they're not included?
They're not included.
Okay.
No.
Alderwoman Conley.
So, and I'm sorry, because what you just stated triggered something. So you're saying that it is statutorily required that you state your reason for having an assistance with voting, is that correct?
Right, it does.
So, and I'm looking at just quickly 4 of these affidavits that have no marking, no name of the voter, no marking as to why the voter is getting assistance. It seems to me that there is a significant difference in terms of an inch of space and a complete non-compliance with statutory requirements. I mean, you said they do have to designate, because in this form there are 2 options. It's either I have a physical disability or I'm unable to read the English language.
Right.
So, and you said that if you have to state one of those.
That's correct.
Okay, so any of these affidavits that don't contain that information would be affidavits that are not to be allowed.
I would disagree with that because, once again, going back to the materials that we have, let's remember with the Mary Bryant home individuals and the affidavits that have been submitted to you from their staff members, all right? One, they're all residents of the home, and the address for them is the Mary Bryant home on their certificates.
These don't have addresses on the affidavits.
Well, the corresponding document, which is the certificate of registered voter, that goes with the if you look, for example, on challenge 8730, The next document is the certificate of registered voter, and it has the name of Kim Martini, 2960 Stanton. All right, that is the same address as the Mary Bryant home. And it's clear from the evidence that we've submitted, and hopefully that you will consider, is that all 10 of the individuals involved are residents, that the procedure had been in prior elections, and what they had done on this election is that one of the staff members went to the election judges, for example, Earl Roy, with a list of all the people of the home that were going to vote that day. And that's what she did that day. She gave them that list. The understanding is that the election officials then would get all the documents together, so it would be an ease of process, okay, for these voters to vote, all right? And if you read these affidavits, that's, in a sense, that's what happened, okay? So I submit to you that this precinct, which is in Mary Bryant home, is that these individuals, you know, appeared before the election officials in the Mary Bryant home. They knew they were residents of the Mary Bryant home, and to be a resident, you have to be blind or have significant visual impairment. So they knew why they were there. They knew what the nature of the disability was. That doesn't excuse necessarily not having them complete this form. But what's interesting on this form is that who was supposed to actually sort of complete it? The blind individual trying to mark all these boxes? I understand what the form says, and boy, I wish they were completed, you know, the way they're designed, okay? But they were not. But they do bear the signatures of the people involved, okay? Once again, not in the right locations. I understand that.
Well, it's more than not the right location. I mean, some of the information is completely missing.
Absolutely, that's true.
Okay, thank you.
So, Mr. Mayor,
Alderman McMiniman.
so with regarding to these invalid affidavits, they're not associated with a particular ballot. Is that correct?
That's correct. We have no idea how they voted.
So this is a very different situation. These invalid affidavits is a very different situation than the 3 ballots that have initials in a different place than the exact line. In one case, we've got ballots of voters who fulfilled all the requirements as a voter, and we have a situation where an election judge initialed it, and we believe it to be an election judge that was there that day, on election day, and the initials are, you know, an inch away from where the line says that they recommended they should be. But then these affidavits, these are not ballots. These are just affidavits for helping someone to vote, and we don't know which affidavits these affidavits belong to, which ballots they belong to. Is that correct?
Yes, that's correct. One, we don't know how the blind voters voted. We don't know that. We do know, though, that they filled these out at the direction of the election judges. All right, and so in both instances, you have the election judges here potentially deciding these things, as opposed to the voters.
So the point I'm making is that the hearing officer followed state law that and case law that if you've got invalid affidavits and you don't know which ballots they belong to, then you use this proration method to assign, rehabilitate all the ballots.
Yeah, and the hearing officer is correct. In that situation, and in prior cases I've been involved in, that's why proportionate reduction occurs when you can't identify what the vote was.
All right, thank you.
Sure. Thank you.
Any other questions? Thank you.
Thank you very much.
Next item is to have the hearing officer come back and present according to the comments that have been made by both sides. And at this time, if you'd take the time to silence your cell phones, we'd appreciate it.
Welcome to my world. I feel like now I'm in the same situation when I used to be for the hundreds and hundreds of jury trials that I conducted. What I would say to the jurors was, today, you get to be a judge. You do what I do every day. You have to listen to these arguments, apply the law, look at the facts, and as someone pointed out very clearly, use your common sense and make a decision. When you make a decision, something that I learned early on, you don't please everybody if you do it right, because you've made a decision. Someone wins, someone loses. For example, in this particular case, you can't make both parties happy. We have two very qualified candidates that both would serve well here, but you have to make a decision. Mr. Gregory says everything that I've said and recommended is great, except one thing, 2 votes I want. I want 2 votes with the issue about the initials over to the side. And if you do that and do everything else, I say, then he wins. Simpson says, well, we don't agree with everything, but we like his result. It says Simpson wins, but we think you ought to just count them all. And if you do that, Simpson gets 4 more votes. Gregory can get 5 more votes. We end up with 468 to 465. Simpson still wins. Or you can take my recommendation and Simpson wins. I think it's kind of coming down, sounds like, from the questions, whether or not you think it's required that those initials on those 2 ballots for Gregory and 1 for Senior has to be on that line. I'm of the opinion that when you train your people, your election judges, and the State Board of Elections has trained your election judges to put their initials in that spot, that's where they should go. Otherwise, you're opening the door for all kinds of problems. If somebody starts doodling on a ballot, are we going to say that's an initial then, and we should count it then? Because it wasn't in the spot, but they doodled while they were thinking about who to vote for. I mean, I don't think there's any question that that was the election judge's initials over there. My reading of everything, nobody's saying that it wasn't, but it wasn't done right. If she could do it right on other ballots, why didn't she do it on these? So I say you got to have them follow the rules. That's what I'm saying. That's what some of you have said. And I think you have to be consistent, even though there is distinctions. That's what's on the affidavits, what's on the initials. I think if you're going to say follow the rules, you follow the rules as to everything. It's a harsh result with regard to disabled voters if we're saying that, but how else are you going to get the people on the front lines in these precincts to do it right? If you start saying, substantial compliance is good enough. Substantial compliance is good enough. No, you want compliance. You want it done right. That way, you will protect our elections and you will protect these results. I urge you to accept my recommendation. I urge you to make a decision tonight. I think you have what you need to make the decision. Please make the decision tonight. These folks have been waiting months. They need to go on with their lives. The longer it goes on, the worse it is for the one that loses. So let's make a decision and go forward. Thank you so much for all your patience and understanding, and wish you the best in making this decision. And in a way, it's kind of unique. It's kind of like watching a jury make a decision, because the juries do it in private. You folks are going to be doing it openly. I will tell you, in my experience of talking to jurors afterwards for over 40-some years, it seems like what they usually do is they kind of take an initial vote. In other words, in this particular case, if someone feels inclined to make a motion to move that my recommendation be accepted and someone seconds it, and you discuss it and vote on it, that kind of give you an idea whether you need to go further into anything else. If you're going to accept it, you're done. If you don't, well, then there's going to be some more talking. That's what they usually do in a jury case, they tell me, is they sit down and say, hey, if it's 8-4 or 6-6, we got a lot of talking. If it's 11-1, well, maybe it's not going to take us too long. So that's what I'm just trying to tell you. You can do whatever you folks want. You make the final decision, and I'm glad you do. Good luck to you.
Thank you. Any questions or discussion? Is there a motion?
There a motion?
Alderman Redpath?
Mr. Mayor, I move that we accept the recommendation of the hearing officer as submitted.
Second.
Any discussion?
Discussion, Mayor.
Alderman McMinimum, then Alderwoman Turner.
I think Alderman Simpson and candidate Gregory are outstanding individuals to represent their ward, and they have both received strong support from their ward, and I could work very well with either individual, and they both bring qualities that we need at the Horseshoe. I won't be able to accept the hearing officer. I think the hearing officer's made an outstanding report in many respects, but I think that when it comes to the 3 ballots that were submitted by voters, the voters completed all their requirements, and it seems unfair to me that a judge can invalidate the will of 3 voters by simply putting their initials in a location that some might view as an improper location. To me, those initials are up at the top right where they belong. They're not exactly on the line. There's no statutory law that says the initials have to be on a particular place on the ballot. So I do disagree with the hearing officer's report. So if we take this to a vote, I'd have to be a no vote to accept the hearing officer's report in totality.
Alderwoman Turner?
I wanted to address the request that I recuse myself from the vote. I will say that, and I've said this on a number of occasions to a number of different people in this room and outside this room, that this has been an extremely arduous process that has caused a great deal of upheaval throughout the Springfield community, and most especially within my community. There have been some very nasty comments, social media, directed at people who are just part of the process because we sit in these chairs, not because we were fact finders, not because we played any role in anything that was brought forward by any of the bodies, any of the people presenting today. And I think that no matter the outcome, there is going to have to be a great deal of coming together and healing, because a lot of people have been significantly hurt, and that's very unfortunate, because at the end of the day, we all want what's best for Springfield. We all want what's best for the Eastside community, and in order for us to get there, we can't treat each other the way that we have over the last few months. It's also believed that no matter the outcome tonight, this will most likely move to circuit court. Unfortunately, tonight probably won't be the end. So while I'm not required to, but if it is believed that my recusal will lead to the appearance of a more fair outcome tonight and at the circuit court, then I will do that, because this is a process that is bigger than all of us, and we need to do better.
Alderman Hanauer?
Thank you, Mayor. You know, when it comes down to it, it's about the voters. And I think that, you know, I said all along, we need to take the voters into account on this. And if I had my way, which, you know, the judge said it, count the 3 that with the initials off to the side and count all the Mary Bryant home. Because the voters, none of the voters that voted there had anything to do with filling out the form except signing it where they were supposed to sign. It's, you know, and Alderman, you said that, you know, election judges, you know, because they signed off to the side. Well, what about not filling out a form correctly? That's just as bad as putting your initials over off to the side. And so, according to the judge, if you do that, Ms. Simpson is still the winner. I think, in my mind, we count them all, but because it doesn't alleviate the judge's recommendation, it doesn't change it. That's why I say go with the judge's recommendation. I think it's a sad day when you have voters that cast the vote and they don't count. I think it's a sad, and I don't think it's the judges. I don't think it's the election judges' intent to make these mistakes. I think at the Mary Bryant home, I could just imagine everybody showing up at once and they're just trying to get people through, and they cut corners. And now we see what happens on it. And so that's why I say we go with the judge's decision, or we count them all. Thank you.
Any other comments? I guess I'd refer to Corporation Counsel with regards to the question about Alderwoman Turner. And, you know, we are a nonpartisan body. Is that a conflict of interest with regards to casting a vote? I think she can separate that out. But I'd like to hear your opinion with regards to that, because keep in mind, even though it might have been a party situation, it's the committeemen that vote for an endorsement, not necessarily the chairperson.
Our respondent in this case raised this today, and I don't think there was any filing regarding a claim of conflict. I do not believe that it constitutes a legal conflict. Normally that relates to a pecuniary, you know, like a contract issue or something like that under the state law. That being said, each alderperson must be the judge of themselves in terms of when they feel a conflict exists. I don't think it would be a legal conflict, because normally that's related to economics, you know, where a party's involved.
Any other discussion? So it's been moved and second. I guess it's a roll call vote.
Roll call. Yeah. Alderman Redpath.
Aye.
And this is, again, to reincorporate conferring with the hearing officer's recommendation.
Alderwoman Turner.
I'm not voting.
Alderman Fulgency.
Aye.
Alderman Proctor.
Aye.
Alderwoman DeCenso.
Aye.
Alderman McMiniman.
No.
Alderwoman Conley.
No.
I'm sorry.
No.
No, thank you. Alderman Donnelly.
No.
Alderman Hanauer.
Aye.
Mr. Mayor, you have 5 yeas, 3 nays, and 1 abstention.
And I'm going to err on the democratic process. I think every vote should be counted, so I'd vote no, and I think we should review the ballots and make determination on Thursday.
Thank you, Mr. Mayor.
What's the final?
5-5, so we need 6 votes.
This vote invalidated?
Mr. Mayor. Point of order.
Yep, Alderman Hanauer.
I am not able to be here on Thursday, just to let you know.
There'll be a 5-minute break before the committee as a whole starts.
We didn't adjourn. Hi, Rosa, how are you?
How are you?